Hello, everyone, and welcome to One Civil Law, where we learn through the misfortunes of others. Today, we begin the actual substantive part of the trial of the Chad Daybell case, triple murder case out of Idaho, involving some cult allegations. We are about 20 minutes behind right now from the court feed. We're going to pick up where the court started, and we'll catch up during a break. So we're about 20 minutes behind, so let's go ahead and just get started.
All right, good morning, everyone. We're on the record now on Fremont County case CR 22-21-1623, State of Idaho versus Chad Daybell. Let me confirm with our tech people and clerks here, is the broadcast on?
Yeah.
Thank you. The court will note that as we get started, there is a courtroom conduct order in effect that you've all been advised. Please pay attention to the terms of that order, including making sure you don't have any devices that would go off and interrupt the proceedings, no recording within this courtroom or photography of any type. The court is providing public access through the open proceedings as well as the live stream that's being conducted. With the court's live stream, we have, I think, the technology in place to accomplish that. If something comes up that interrupts the live broadcast of this trial, and this will be throughout the trial, we'll give an opportunity to try to get that started again. However, if there's going to be any kind of significant delay in the live stream broadcast, the court will be continuing on with the proceedings. So there may be gaps in that, but I think our technology is in place that hopefully that won't occur. Just so those listening in understand, if it does come up, we likely will not pause the trial longer than necessary to make that accommodation. At this time, I'll note also for the benefit of counsel, we do have all 18 jurors, our 12 jurors with 6 alternates have arrived this morning, and everyone has submitted their juror affirmation sheet regarding following the court's admonishment while they've been gone. No issues to bring up on the affirmations of the jurors. So with that in mind, then let me go to the state, knowing the state is here present. Is the state ready to proceed this morning?
Yes, Your Honor, thank you.
And is the defense ready to proceed?
Yes, Your Honor, thank you.
Okay, thanks, counsel.
All right, and I just posted my workout from today, which is the reason I'm 20 minutes late, so excellent.
I also, as we are getting started and before the jurors are sworn and we take evidence, is there, I believe we've already had a motion to exclude witnesses. Let me just clarify on the record, is there going to be a motion to exclude witnesses through evidence portion of the trial made by the defense?
Yes, Your Honor.
Very well. The court will reaffirm then there has been a motion to exclude witnesses. So as the state begins with its case in chief, keep that in mind that they are not permitted to observe the trial proceedings, including the live stream. The only exception would be for a witness. If they statutorily qualify as a victim, then they are permitted to observe the proceedings. So each witness is going to be questioned whether or not they've observed any trial proceedings, and I would instruct the state and then following the defense, they have witnesses to make sure that the exclusionary rule is followed. Does the state have any questions on that matter?
Your Honor, the state would just clarify and just make counsel and the court aware. It's the state's understanding that through the Constitution and statutorily, victims have a right to remain in the courtroom throughout the proceedings, regardless of whether or not they are victims. And we have discussed that with defense counsel and made the court aware of who we think there may be a crossover with, meaning individuals that may be present and also witnesses. But statutorily, they would have the right to be here. So including any of the defendant's children, as well as if they were Tammy's children, as well as siblings, sometimes grandparents, The court made a ruling last year in the Lori Vallow case. I think if we're following a similar guideline, those are the individuals that we would just note for the record may be present at times, but should have the right to be present throughout the proceedings. In addition, I would just note for the record that we do have our case agent who will be present for the duration of the proceedings, and that's Chief Deputy Vince Kaikamani.
Okay, and the state's permitted their case agent as it relates to victims. The court agrees they are permitted to see the proceedings, including if they are a witness, who would take up on a witness by witness basis whether or not they fall within the statutory qualifications permitting that. And I know the state's aware of the issue. Will make rulings contested as to whether or not they qualify and are later called to testify. Mr. Pryor from the defense, any further comment or questions on the exclusionary ruling?
Nothing further, Your Honor.
Okay, thank you.
Glad to have you here,
All right,
Varro.
this time then we will.
And hello from Brazil. Glad to see you here this morning.
Yes, sir. All rise.
Oh, the jury's present and accounted for.
All right, thank you, Mr. Bale. Please be seated. All right, thank you, ladies and gentlemen of the jury. We're on the record on Fremont County case CR 22-21-1623, State of Idaho versus Chad Daybell. We're ready to proceed with opening arguments and initial instructions this morning to you as jurors. The court notes that the prosecution is present as well as the defendant and Chad's attorney representing him as well. We have qualified this panel of 18 jurors consisting of 12 jurors with 6 alternates, and they are now seated for trial. Let me start with the state and ask, will the state agree that the jury has now been properly seated and ready to be sworn?
Yes, Your Honor, thank you.
Will the defense agree as well?
Yes, Your Honor.
Thank you. All right, ladies and gentlemen of the jury, thank you for returning this morning. You're now seated as jurors in the case before us. As previously been told, I'm Stephen W. Boyce, the District Judge of Fremont County in charge of this courtroom trial. I'll briefly reintroduce you to some of our court personnel assisting here today. Shannon Wolstein, seated to my right, is the clerk who is keeping minutes of the trial proceedings, will be marking trial exhibits and administering oaths to you as jurors and to the witnesses. We do have our courtroom bailiffs as well who assist with keeping order in the courtroom and helping the jury move about where they're supposed to throughout the day, and then enforcing any conduct orders we have.
Thank you, Tony, for the gift memberships as always.
Our court reporter today in Bland is taking a stenographic record of everything said during the trial proceedings, and my staff attorney, Courtney Stallings, is seated to the far right, who assists me with legal research and administrative matters that come up throughout each day of trial. Each one of you has been qualified, examined, and selected to serve as a juror of this court. The clerk will now have a roll call of our seated jurors. Please, Madam Clerk, if you would conduct the roll call. As to each juror, once your juror number is announced, please just indicate present or here verbally so we acknowledge that on the record. Madam Clerk.
Juror 27, present. Juror 219,
Here.
Juror 505,
Here.
Juror 631.
Here.
Juror 653.
Here.
Juror 686.
Present.
Juror 752.
Present.
Juror 1680. Present. Juror 823.
Here.
Juror 1358.
Here.
Juror 1365. Yeah. Juror 716. Yeah. Juror 751.
Here.
Juror 997.
Here.
Juror 1078. Juror 1577. Here. Juror 1271. Juror 1382.
Thank you, Madam Clerk. This case has been brought by the state of Idaho. I'll sometimes refer to the state as the prosecution. State is here represented in this trial by Lindsay Blake, Fremont County prosecutor. Ms. Blake, could you please stand briefly? Also, Rob Wood is the Madison County prosecutor. Ingrid Beatty is a special assistant prosecutor. And Rocky Wixom is a Fremont County deputy prosecutor. The defendant in this case, Mr. Daybell, is represented by his attorney, John Barr. Thank you, counsel. In a few moments, the clerk will read you a redacted version of the amended indictment in this case. That document is not to be considered as evidence. It sets forth the charges against the defendant. You must not consider it as evidence of guilt and not be influenced by the fact that charges have been filed. Mr. Daybell has pled not guilty to the charges contained in the amended indictment. And please remember, again, it's a description of charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be or what any lawyer may state the law to be. During this course of the trial, including opening statements, you're instructed that you are not to discuss this case among yourselves or with anyone else, including using the internet or social media or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. And do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. The court's given you that instruction now multiple times, and I will continue to give you that instruction. And again, that's not because I don't think you're not paying attention. It's just important enough. We'll keep reiterating that. And I will note we received the juror affirmations today from each of the jurors indicating they have followed that instruction. So thank you for that. At this time then, the next matter we'll take up is to have this jury placed under oath for trial. At this time then, Madam Clerk, if you're ready to administer the oath, I'll have the jurors stand and will be placed under oath. When you stand, then please raise your right hands.
You solemnly swear or affirm that you will try the cause now on trial and the true verdict rendered herein according to the law and the evidence so help you God.
All right, thank you. Please be seated. All right, the jurors have already been advised of some of our trial procedures in this case, and I'll just give you some additional general information here. Our normal schedule is to run trial from 8:30 each day until 3:30. At times that will need to be modified for certain reasons. Sometimes we have matters to be argued outside of your presence. Sometimes during the recesses, they may seem to go on because we're conducting other court business outside of your presence. But we will take recesses through the morning and also in the afternoon. If anyone is uncomfortable, needs a break or recess for some specific reason, please notify the bailiff and we'll do our best to accommodate each of you and keep you comfortable while we're here. In addition, if anyone has any kind of accommodations they need, for example, assistance with a hearing device, other matters, please notify the bailiff again, and we want to make sure you are as comfortable as you can be and able to be alert and attentive throughout the presentation of evidence in the case. These seats that you have been assigned to at this time will be your specific seat throughout the trial. Please return to that same assigned seat each day or after each break so that we are able to determine who's here and if someone's not for some reason who's not here. If there are interruptions at times during the trial, I know that can be frustrating, but we'll work our best to keep those to a minimum, move the trial as long as efficiently as possible, but at times it just takes time to hear motions that are necessary outside of your presence. And then the courtroom and your location for deliberations, as well as during the trial where you'll be held. We've provided, of course, access to restrooms and other needs you may have. I'll address your compensation here. State law allows you for $10 a day for your jury service. However, after 5 days, that bumps up to $40 a day. So this trial is
$40 a day, people. Exciting.
Get into that increased range of compensation, and that's pursuant to Item 2215. You're also entitled, I believe, to a mileage reimbursement for travel each day, and that can further be explained to you if you have any questions. Also, you may notice from time to time, or a lot of the time, I'm looking at monitors here during the trial. You have case information here, availability to access and research things from the bench.
Almost enough for dinner groceries.
You notice, looking at those monitors.
In Idaho, it probably will get you some pretty good meals, to be honest. Cost of living is probably a little bit lower, I'd imagine.
At this time, then the court will provide the jury with some additional jury instructions. As I read through these, it's somewhat lengthy, and I will notify you that you don't have to necessarily memorize everything I'm saying when the trial is concluded and you deliberate. You will have printed copies of these instructions to return to for reference. And if you'll give me just a moment here, I have a brief inquiry to make with my staff attorney. All right, thank you. Now that you've been sworn as jurors to try this case, I'll go over with you what will be happening. I will describe how the trial will be conducted and what we will be doing. At the end of the trial, I'll give you more detailed guidance on how you are to reach your decision. Because the state has the burden of proof, it goes first. After the state's opening statement, the defense may make an opening statement or may wait until the state has presented its case. The state will offer evidence that it says will support the charges against the
We could do a workout chat, and maybe some point in the future. Sometime in the future, maybe we'll do some sort of streaming from the gym or something. Could be fun.
The state may then present rebuttal evidence. This is evidence offered to answer the defense's evidence. After you have heard all of the evidence, I'll give you additional instructions on the law. After you've heard the instructions,
I'll have to figure out how to do that in such a way as to not be obtrusive on other people, though. So that might be a bit of a logistical challenge, because I always hate those people who are filming in the gym and like not caring about other people. So yeah, Kurt a gym thought could be. I'm saying, yeah. Why not? We'll do some butt exercises. It'll be great.
During your deliberations, you will have with you my instructions, the exhibits admitted into evidence, and any notes taken by you in court. The defendant is charged by the state of Idaho with a violation of law. The charges against the defendant are contained in the amended indictment. The amended indictment is simply a description of the charges. It is not evidence.
Yeah.
Jury instruction number 3. The defendant, Tammy Daybell, has been charged in the amended indictment.
I'm already a bit self-conscious as it is. When I was doing squats today, I was looking for this foam thing that goes on the bar, you know, that helps to like protect your neck and stuff, and I couldn't find it. And I was already feeling very self-conscious because I was walking around like in the free weight area, kind of like looking, trying to find this thing, and I'm like, I feel very like someone could look at me and feel like I'm creepy, and I'm just looking for this little foam thing, and it wound up being like right in front of me. It just blend into the background because it's black and I couldn't see it, so that was exciting.
Instruction number 4. It is alleged that the crimes charged were committed on or about or on or between a certain date. If you find a crime was committed, the proof need not show that it was committed on that precise date. Instruction number 5. Under our law and system of justice, the defendant is presumed to be innocent. Presumption of innocence means 2 things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence. Nor does the defendant.
I think my squats were at 100.
Second, the state must prove.
Was it 70 plus 45? Was it 115? Or 125? Something like that today. But I did something like 6 or 7 sets of them. So, yeah.
Or from lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. Jury instruction number 6. A defendant in a criminal trial
like 7 sets at 5 reps at 115, I think.
To testify is left to the defendant, acting with the advice and assistance of the defendant's lawyer. You must not draw any inference of guilt. 10
at 45, 7 at 85, and then I did 1, 2, 3, 4, 5, 6 sets at 5 reps at 115 today.
If during the trial,
so
I may say or do anything which suggests to you that I am
8 sets total today on squats.
of any party, you will not permit yourself to be influenced by any such suggestion. I will not express, nor intend to express, nor will I intend to intimate any opinion as to which witnesses are or are not worthy of belief, what facts are or are not established, or what inferences should be drawn from the evidence. If any expression of mine seems to indicate an opinion relating to any of these matters, I will instruct you to disregard
I have
it.
both a home gym and I'm a member of a gym.
Instruction number 8. Your duties are to determine the facts.
Nate the lawyer was kind enough to pay for a gym membership for me, which, you know, okay. So we could go work out together, which was great. So yeah, I have both a home gym, or more strictly speaking, I have a gym at my apartment complex, which is pretty decent. It's got a cable machine, and if you've got a cable machine, you can kind of do anything you need to do, you know? So yeah. Plus, it's got other stuff beyond the cable machine. I'm just saying that, you know, if you have a cable machine, you can kind of do anything. So, yeah.
Faithful performance by you of these duties is vital to the administration of justice. In determining the facts, you may consider only the evidence admitted in this trial. This evidence consists of the testimony of the witnesses, the exhibits offered and received, and any stipulated or admitted facts. The production of evidence in court is governed by rules of law. At times during the trial, an objection may be made to a question asked a witness, or to a witness's answer, or to an exhibit. This simply means I'm being asked to decide a particular rule of law Arguments on the admissibility of evidence are designed to aid the court and are not to be considered by you nor affect your deliberations. If I sustain an objection to a question or to an exhibit, the witness may not answer the question or the exhibit may not be considered. Do not attempt to guess what the answer might have been or what the exhibit might have shown. Similarly, if I tell you not to consider a particular statement or exhibit, you should put it out of your mind and not refer to it or rely on it in your later deliberations. During the trial, I may have to talk with the parties about the rules of law which should apply to this case. Sometimes that will occur over on the corner there, and we do have a device here.
Nate, the lawyer, and I are a good team. I play the straight man. He plays the comedian.
At other times,
It's a fun little thing we got going on.
While we work out the problems with evidence. You are not to speculate about any such discussions. They are necessary from time to time to help the trial run more smoothly. Some of you have probably heard the terms circumstantial evidence, direct evidence, and hearsay evidence. Do not be concerned with these terms. You are to consider all the evidence admitted in this trial. However, the law does not require you to believe all of the evidence. As the sole judges of the facts, you must determine what evidence you believe and what weight you attach to it. There is no magical formula by which one may evaluate testimony.
I play the straight man in the comedy duo. You've never heard the term before?
Of your lives. In your everyday affairs, you determine for yourselves.
Yeah, go look it up. Straight man comedy. Go look it up.
What you are told. The same considerations that you use in your everyday dealings in making these decisions are the considerations which you must apply in your deliberations. In deciding what you believe, do not make your decisions simply because more witnesses may have testified one way than the other. Your role is to think about the testimony of each witness you heard and decide how much you believe of what the witness had to say. A witness who has special knowledge in a particular matter may give an opinion on that matter. In determining the weight to be given such an opinion, you should consider the qualifications and credibility of the witness and the reasons given for the opinion. You are not bound by such opinion. Give it the weight, if any, to which you deem it entitled. Jury instruction number 9, at the conclusion of the trial, you will decide as to each charge whether the state has proved the defendant guilty beyond a reasonable doubt. The subject of penalty or punishment is not to be discussed or considered by you in making these decisions. That is a matter which must not in any way affect your verdict. Jury instruction number 10. The state is seeking the death penalty in this case. If the defendant is convicted of murder in the first degree, there will then be a separate sentencing phase of the trial. At that sentencing phase, additional evidence may be presented and the jury will be given additional instructions. At the conclusion of that hearing, the jury will then decide if the defendant will be sentenced to death. If the jury decides that the defendant will not be sentenced to death, either the defendant will be sentenced to a term of life imprisonment without the possibility of parole, or the judge will sentence the defendant to a term of life imprisonment during which the defendant could not be paroled for at least 10 years and possibly for life. Jury instruction number 11. If you wish, you may take notes to help you remember what witnesses said. If you do take notes, please keep them to yourself until after you and your fellow jurors go to the jury room to decide the case. You should not let note-taking distract you so that you do not hear other answers by witnesses. When you leave at night, you'll leave your notes here with the dais. If you do not take notes, you should rely on your own memory of what was said and not be overly influenced by the notes of other jurors. In addition, you cannot assign one person the duty of taking notes for all of you. Jury instruction number 12. It is important that as jurors and officers of this court, you obey the following instructions at any time you leave the jury box, whether it be for recesses of the court during the day or when you leave the courtroom to go home at night. First, do not talk about the case among yourselves or with anyone else during the course of the trial. You should keep an open mind throughout the trial and not form or express an opinion about the case. You should only reach your decision after you have heard all the evidence, after you've heard my final instructions, and after the final arguments. You may discuss this case with the other members of the jury only after it is submitted to you for your decision. All such discussions should take place in the jury room. Second, do not let any person talk about the case in your presence. If anyone does talk about it to you, tell them you're a juror of the case. If they won't stop talking, then report that to the bailiff or courtroom staff here as soon as you're able to do that. You should not tell your fellow jurors about what has happened. Third, during this trial, do not talk with any of the parties, their lawyers, or any witnesses. By this, I mean not only do not talk about the case, but do not talk at all, even to pass the time of day. In no other way can all parties be assured of the fairness they are entitled to expect from these jurors. Fourth, during this trial, do not make any investigation of this case or inquiry outside of the courtroom on your own. Do not go to any place mentioned in the testimony without an order of the court to do so. You must not consult any books, records, internet, or any other source of information unless I specifically authorize you to do so. Fifth, do not read about the case in the newspapers. Do not listen to radio or television broadcasts about the trial. You must base your verdict solely on what is presented in court and not upon any newspaper, radio, television, or other media account of what may have happened. Each day, you will be required, as I mentioned, to sign an affirmation that you will follow this admonition of the court. That concludes the court's first instructions then, and as I mentioned, we will be providing copies of those when we deliberate for further reference. Next, at this time, I am going to have the clerk read the amended and redacted indictment to you. Madam Clerk, if you're ready to read the amended indictment, please do that at this time.
The District Court of the 7th Judicial District of the State of Idaho in Florida County of Fremont. State of Idaho plaintiff versus Chad Daybell defendant, case number CR 22211623, amended indictment. Chad Daybell is accused by the grand jury of Fremont County of this indictment as follows. Count 1, conspiracy to commit first-degree murder and grand theft by deception. The defendants Chad Daybell and or Lori Vallow and or Alex Cox, deceased, and or other co-conspirators, both known and unknown, on or between the dates of October 26, 2018, and continuing until January 15, 2020, in the county of Madison, state of Idaho, and elsewhere, including Fremont County, Idaho, and as part of a continuing criminal transaction and common scheme or plan in Madison and Fremont counties, Idaho, did willfully and knowingly combine, conspire, confederate, and agree to commit murder in the first degree of Tylee Ryan and to commit grand theft by deception. Count 2, first-degree murder. The defendant, Chad Daybell, on or between the 8th and 9th day of September 2019 in the county of Madison, state of Idaho, and as part of a common scheme or plan for continuing criminal transactions.
Hello, Johnny. How are you doing?
In Madison and Fremont counties in Idaho, were concerned in the commission of a first-degree murder and did aid and abet its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with premeditation, which resulted in the death of a human being, to wit, either kill Tylee Ryan and or assist in the killing of Tylee Ryan, and or did encourage the killing of Tylee Ryan, and or did command another to kill Tylee Ryan in violation of the oath. Count 3, conspiracy to commit first-degree murder and grand theft by deception. The defendants, Chad Daybell and or Lori Vallow and or Alex Cox, deceased, and or other co-conspirators, both known and unknown, on or between the dates of October 26, 2018 and continuing until January 15, 2020. Excuse me. In the County of Madison, State of Idaho, and elsewhere, including Fremont County, Idaho, and as part of a continuing criminal transaction and common scheme or plan in Madison and Fremont counties, Idaho, that willfully and knowingly combine, conspire, confederate, and agree to commit murder in the first degree of Joshua Jackson Vallow, hereinafter J.J. Vallow, and to commit grand theft by deception. Count 4, first-degree murder. The defendant, Chad Guy Daybell, on or between the 8th and 9th day of September 2018, in the County of Madison, State of Idaho, and as part of a common scheme or plan for continuing criminal
Thank you, Cynthia,
transactions
for becoming a
between Madison,
non-civilian. We
Fremont
do
counties,
appreciate
and Idaho,
everyone who hits that beautiful, beautiful join button for only 99 cents a month to help support the channel. It helps the channel grow, and thank you.
Advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with premeditation, which resulted in the death of a human being. To it, did either kill J.J. Vallow and or assist in the killing of J.J. Vallow, and or did encourage the killing of J.J. Vallow, and or did command another to kill J.J. Vallow in violation of Idaho Code. Count 5, conspiracy to commit first-degree murder. The defendants, Chad Guy Daybell and or Lori Vallow and or Alex Cox, deceased, and or other co-conspirators, both known and unknown, on or between the dates of October 26,
Thank you, Donna D, for becoming an uncivilian, for hitting that beautiful, beautiful join button for a mere 99 cents a month and helping to support the channel. We do appreciate it.
And elsewhere, including Madison County, Idaho, and as part of a continuing criminal transaction in common scheme or plan in Fremont and Madison counties, Idaho, did willfully and knowingly combine, conspire, confederate, and agree to commit murder in the first degree of Tammy Daybell, and did combine or conspire to commit murder, and one or more of such persons did enact to effect the object, combination, or conspiracy. Count 6, first-degree murder. The defendant, Chad Guy Daybell, on October 18 to 19, 2019, in the County of Fremont, State of Idaho, was concerned in the commission of first-degree murder and did aid and abet in its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with premeditation, which resulted in the death of a human being. To wit, did either kill Tammy Daybell, and or assist in the killing of Tammy Daybell, and or did encourage the killing of Tammy Daybell, and or did command another to kill Tammy Daybell in violation of Idaho Code. Count 7, insurance fraud. The defendant, Chad Guy Daybell, on or about October 19, 2019 through October 30, 2019, in the County of Madison, State of Idaho, did with the intent to defraud or deceive an insurer for the purpose of obtaining any money or benefit, insurer or other person, a statement as part of or in support of a claim for payment or benefit, knowing that such statement contains false, incomplete, or misleading information concerning any fact or thing material to such claim, to wit, that present and or cause to be presented an insurance beneficiary form to Life Map Assurance Company in violation of Idaho Code. Count 9, insurance fraud. The defendant, Chad Guy Daybell, on or about October 19, 2019 through October 31, 2019, in the County of Madison, State of Idaho, did with the intent to defraud or deceive an insurer for the purpose of obtaining any money or benefit, insurer, or other person, a statement as part of or in support of a claim for payment or benefit, knowing that such statement contained false, incomplete, or misleading information concerning any fact or material thing to such claim, to wit, did present and or cause to be presented.
Yeah, on my Supreme Court petition,
to Primerica Life
if the Supreme Court does grant review, I feel pretty decently
Signed
good
an issue
about
bill
winning.
On the 24th day of May,
Um,
2021.
the really tricky part is getting them to grant review. That's the hard part. But if they do grant review, I feel
To these charges, the defendant
modestly
accepted the plea of not
decent about actually winning.
All right, thank you
So,
very much, Madam
that's
Clerk,
nice.
for reading the redacted amended indictment. In this case, again, I will advise the jury to remember the indictment is a description of charges. It is not evidence.
Of course, if they
That
actually
concludes
do
the
grant
court's
review,
opening instructions
you will
and
then get the
reading
privilege of seeing
indictment.
uncivil law
The
go into a
jury's
full-bore
as well.
panic
The next
for several
matter we
months
will
as
take up
he
are our opening statements.
preps his
And require
brains
the
out.
state to stay ready to proceed with evidence. Yes, Your Honor.
So,
Beginning the opening statement.
That'll be entertaining to watch for everybody.
Mr. Wharton, you may present your opening.
Lord.
Your Honor, may I inquire, is there a hand mic so that I may?
That's the part of the exercise where I
Take this moment to-
start having to cram the record into my memory, among other
And I do
problems.
have a PowerPoint attached.
All right.
Yeah. Yeah. But
May I proceed your vote?
I think it will be okay.
Yes,
In
it's
the
for
end.
HDMI.
How did I get started in constitutional law? In a lot of ways, I started my interest in law, in constitutional law. That's sort of the reason I got interested in law in the first place. I've told this story before. The reason I got into law was because I found a, pocket constitution when I was like in fourth grade or something. And I was just completely fascinated by it. Although my case isn't a constitutional law case. I can't say that much. It's statutory. So it's not a constitutional law case. It's statutory, but
Of his wife, Tammy Daybell.
that's fine.
The defendant is photographed laughing and dancing on a beach in Hawaii at his wedding. It's Lori Vallow, a woman who was his mistress and the mother of the children buried in the graves on his property. 3 dead bodies. This defendant believed he had a right beyond the ordinary. When he had a chance at what he considered his rightful destiny, he made sure that no person or no law would stand in his way. His desire for sex, money, and power led him to pursue those ambitions. And this pursuit led to the deaths of his wife and Lori's 2 innocent children. Chad Daybell is an author who wrote books about the apocalypse. During this trial, you will hear a story more troubling. And the story is real. Chapter 1. The defendant was a seemingly ordinary man. You'll see that he craved significance. He worked in journalism and he worked as a sexton in a graveyard. He married his wife Tammy in 1990 after meeting at Brigham Young University, and they settled in Utah. As a full-time homemaker and mother, Tammy's love for her family was boundless. Together, Tammy and the defendant started a small publishing company, which Tammy supported in many ways. They had 5 children together. They moved to Idaho, where Tammy became a beloved school librarian. She was devoted to service, her community, and her faith. But for this defendant, that ordinary existence was not enough. Chapter 2. Lori Vallow was a homemaker.
Chapter
from
2.
Arizona. Your Honor, this might just. Sorry, Mr. Lee.
Let's see if we get a replacement.
It's a very that's
Okay.
explicit signposting,
PowerPoint is not up.
and that's
I think your mark's off.
signposting. By the way, is
I didn't turn it off this time.
when you sort of delineate separations in your speech. but most people who are trained speakers do it subtly. You know, I know. I've never heard. That's a pretty explicit signposting. Now, chapter 2. What? Yeah.
You want to close the screen as well.
Your Honor, it's up on the screen, and I can't explode in the HDMI. I'm not sure why it's not transferred.
All right, a little clumsy.
That.
Also, some technical
Let's
problems.
see if we can get some help to maybe see if we can get the signal to work on that.
Oh, great. Technical issues in the middle of opening argument. Some guy, who I assume is an IT guy, wearing sneakers in the courtroom. I mean, dude. Come on. I don't care who you are.
Sorry.
Damn.
Can I proceed?
Yeah, but I'm still not sure on the mic is that not working.
Put on some Oxfords or something. Shit.
Apologies for the interruption. Writing down. Chapter 2. Lori Vallow was a homemaker from Arizona. She was married to her fourth husband, Charles Vallow, and she was the mother to Tylee Ryan and JJ Vallow. Tylee was a normal, vibrant teenage girl. She loved her friends. You'll hear that she loved her Jeep. She loved Chipotle. She loved her little brother, JJ. JJ was a 7-year-old boy on the autism spectrum. He required extensive special care needs. He loved his sister. You'll hear about a pivotal date that set in motion the deaths of Tammy, Tylee, and JJ. October 26, 2018. That was the day when Chad Daybell and Lori Vallow met at a religious conference in St. George, Utah, where they were introduced by a mutual acquaintance. At this time, both still married to other spouses. That introduction set in motion the reality you're going to hear about. We know what happened next through the defendant's own words. You'll hear. Though both married, Chad and Lori began to have an affair. You will hear excerpts from the defendant's extended text messages to Lori that reveal his mindset and his motivations. In his thirst for sex, power, and money, Chad created an alternate
Very
reality
bad
where they call themselves James
vocal
Middleman,
variety.
names that Chad
And he's not hitting it properly. Like, it's just his desire for sex, power, and money, as opposed to his desire for sex, power, and money. Right? A little bit of vocal intonation, a little bit of spacing to let it hit would be better.
He was captivated by her appearance. So much so, he said she was out of his league. You will hear evidence in his own words, how he was taken by her beauty and spoke about their sexual encounters on many occasions. More than anything else,
Has he practiced this at all?
Chad's obsession with Lori was rooted in her adoration for him. She was the mirror reflecting the grandeur he saw in himself. He called her an
It's
exalted
not
goddess.
theatrics,
He told
or
her
at least he's
tonight
not doing theatrics. He should be doing theatrics, and he's not. His presentation sucks. Yeah, touch of theatrics, exactly. He's wandering around aimlessly. He's not moving with purpose. He's just sort of wandering around. He's not moving to emphasize a point. He's not moving in any sort of deliberation.
You'll hear that in the world that Chad and Lori planned for themselves.
In chapter 3,
They identified those
with the
who stood
signposting.
in the way of their dream as dark. Their spouses, Lori's own children, and any who oppose them were labeled sometimes as dark spirits or even zombies. This was more than an alleged belief of right-wing labor. The evidence will show that it was a convenient narrative that dehumanized people who stood in their way and were labeled as obstacles. This narrative gave them the pretext to remove people from this world for their own good. Chad and Lori preached that only through spiritual intervention, what they sometimes call casting, sometimes through burning, or even through death, would these dark spirits be cleansed. Enter Alex Cox, Lori's devoted brother. Chad and Lori manipulated Alex with promises of spiritual rewards.
Enter Alex
They
Cox,
wielded
his
their influence over
brother.
Alex,
Again, a little
drawing
vocal
him into
intonation.
their plotting
Maybe, you know.
and planning of their own future.
Entering our story.
After the death
Alex
of
Cox.
Tylee,
I mean,
JJ,
just
and
like
Tammy,
anything.
Chad Daybell gave Alex a blessing. This blessing was reported by Lori, who was present. And in that blessing, he said to Alex, "You have earned the privilege to be a member of their exclusive religious group." And he also said to him, "You have already assisted us in ways that can never be repaid." But you will also see other text messages. Chad and Lori discussed more earthly concerns, that Alex could be the one to implicate them. Alex knew this as well. Shortly before he died, on December 12th, 2019, he told his wife, Zuana Pastenis, who you will hear from, he was afraid he was going to be Chad and Lori's fallback. Chapter 4. Once their calculated plan was devised, it only took months to execute and remove perceived obstacles in Chad Daybell's path to a new life. Charles Vallow, Lori's husband, who was labeled as dark by the defendant, was shot and killed by Alex Cox in Arizona. Lori stood to gain $1 million.
How do you make a triple murder sound boring?
Chad and Lori's future. Yet following Charles's death, Lori Vallow awaited a $1 million life insurance payout that never came, only to learn that the beneficiary was no longer her. Upon learning she would not receive that insurance money,
Dude,
Lori
get yourself a
confessed Chad.
lectern and just stay
I'll
there.
look at the $4,000
Put the papers
a
on the
month for
lectern.
assets.
You're not moving with any
Security.
purpose. Just get a
Chad replied to
lectern.
her in a text that read, "It will be interesting to see if it got changed after he had 2 bullets in his chest." Tylee Ryan, also branded Dark and a zombie, was last seen on September 8th, 2019. Subsequent investigations revealed the horrifying truth. Her remains, charred and dismembered, were found in a grave on Chad Daybell's property. Without Charles's $1 million in insurance money to support them, Lori Vallow continued to illegally receive Tylee's Social Security benefits, provided after the death of Tylee's biological father, who had been Lori's third husband.
Everything he's saying just goes in one ear and out the other.
JJ
There's
Vallow,
no retention of
Lori's son, was
information.
also possessed.
I don't even know what he's
After
been
he was
talking
labeled as
about.
dark
I've been
and
listening to him for like
his
20
fate was no
minutes.
less tragic than his sister's.
There's no vocal variety, no vocal intonation, no pausing.
Later, his bound body was discovered buried. in
It
Chad's
just goes
backyard.
in one ear and out
His
the
death
other.
by
I have
suffocation.
no retention.
Yet while JJ was missing, Lori continued to illegally receive JJ's Social Security benefit, money provided by Charles Vallow's dad. Tammy Daybell, a vivacious, healthy mother, was another individual labeled as a dark spirit to be removed. On October 9th of 2019, she reported being shot at night near her home by a man covered in black. She thought it was a paintball gun. On October 19th, 10 days later, she died in her own home with her husband present. This was soon after an increase.
I'm beginning
in the
to think that
value
law
of
school
life
should
insurance
require an
to more than
acting class.
$400,000. This defendant rapidly cashed in that life insurance and began looking for condos in Hawaii with Lori. You'll see the rental application he submitted for a couple with no kids. Medical examiners would later determine that the only reasonable explanation for Tammy's death was not of natural causes, but rather a homicide. In fact, you will hear from multiple witnesses that Chad predicted multiple times that Tammy would die of an early death. Chapter 5.
Who
17
taught
days
him?
after his wife's death,
Who taught him that
Chad Daybell
labeling parts of
and
his
Lori Vallow
speech,
got married
chapter 1,
celebrated
chapter
on the
2,
beach
chapter
in
3,
Hawaii,
chapter 4,
Hawaii,
chapter 5 was a good
symbolizing what
idea?
he called their eternal union
Who taught him that was a good idea?
Chad and Lori.
Did he read something about the importance of signposting and he decided to just crank it all the way up to 11?
Tammy is still alive.
That's not what we had in mind, man.
Now, without the earthly obstacles of spouses and young children, and with Tammy's insurance policy and the children's social security funds, they could live the life that Chad and Lori wanted. Nothing was going to stand in their way. Chapter 6. Unfortunately for this defendant, reality soon shattered their bliss. Two things led law enforcement to his and Lori's door. On October 2nd, 2019, Lori Vallow's nephew-in-law, a man named Brandon Boudreaux, was shot at in Arizona by someone from what he believed was Tylee's Jeep. Law enforcement in Arizona investigating Brandon's shooting contacted law enforcement.
Yeah, signposting is like the guys in Futurama. If you do it right, they won't be sure you've done it at all.
For Tylee's Jeep. And you'll hear that Jeep was later found
Yeah, I mean,
in Madison County.
much more of that than not.
Meanwhile, J.J. Vallow's grandmother, concerned that she hadn't seen or heard from him in months, asked police for help. The police followed up and located Lori in Rexburg, Idaho, where the police did a welfare check at Lori's apartment. Law enforcement arrived at Lori's door on November 26, 2019. When asked about Lori, Chad first told law enforcement he didn't know her very well, despite the fact that they were married and had been in a relationship for over a year. Lies by Lori to police about JJ and Tylee's whereabouts, and then a move to
If he's
Hawaii,
trying to do
and
some sort of
Lori's
parallel
unwillingness to present her
to
children law
Chad's
enforcement
books,
to prove their well-being led to her arrest and
it's not
extradition.
working.
As Lori refused to produce her children, law enforcement continued their search for Tylee and JJ. During that search, they located a unique text message this defendant, Chad Daybell, had sent to his wife Tammy on September 9, 2019, which was the day after Tylee Bryant's last known appearance. You'll hear from the
You know, if you
FBI
go
agent
see a
that that
if you go
message-
see a theatrical
that this
production,
message seemed
they don't
longer
like
than his
explicitly
usual text,
say,
Tammy,
you
and had a
know,
more
this is
conversational tone.
Act
that
5,
text,
Scene 3.
Chad claimed he had an interesting morning.
They don't come out and just verbalize it. Oh, okay, now it's Act 5, Scene 4. Whoa, right? That's not how you do it, man.
When law enforcement finally went to the defendant's property the following June, they didn't find a raccoon. They found Tylee's burnt remains were buried in that cemetery. And they found JJ nearby, buried under a tree near a pond. Ladies and gentlemen, you've been told this would be a lengthy trial. You will hear from many witnesses. You will hear a
Well,
lot
at least he
of
kept it short. That's
You're
nice.
going to hear a lot of dates. The following is just a timeline of major events to help understand when these things took place. October 26, 2018, Chad and Lori meet in St. George, Utah. July 11, 2019, Charles Vallow, Lori's husband, shot and killed by Alex Cox. Between August 31st and September 1st, Lori, Alex Cox, and Tylee and JJ moved to Rexburg, Idaho, just a few miles south of the defendant's home. Tylee's last known sighting was September 8, 2019. The text I just spoke of about the raccoon was sent by the defendant to his wife September 9th, 2019. JJ's last known sighting you'll hear about September 22nd. The attempted homicide of Brandon Boudreaux in Arizona was October 2nd. The shooting I mentioned of Tammy, the shooting at her, the unsuccessful shooting, October 9th, 2019. Tammy's death, October 19th, 2019. 17 days later, Chad and Lori marry in Hawaii. Law enforcement did a welfare check looking for JJ November 26, 2019 in Rexburg, Idaho. November 26th and 27th, Chad and Lori leave town. June 9, 2020, Tylee and JJ's remains are found on Chad's property. As I said, you're going to hear a lot of evidence from a lot of witnesses. And there's going to be kind of different groups of evidence you're going to hear from. You'll hear from law enforcement, some of whom will give you a broad overview of the investigation and what they did, how the search for Tylee and JJ ended to a case of murder. You'll hear how it began by people who knew Lori and Chad, the James and Elaine. You'll hear about the James and Elaine story and about their relationship with each other and how they pursued their dream, their plan for a life together.
I have a dream.
You'll hear from the defendant's own words, people referred to as obstacles,
I have a dream.
how they need to be gotten rid of. You're going to hear financial evidence. You'll hear from an FBI forensic accountant and a detective, a Social Security administrative investigator who will talk about the finances involved in this case. You'll hear more from law enforcement, from multiple law enforcement agencies, the Rexburg Police, the Fremont County Sheriff's Department, the FBI, Social Security Administration, about the investigation into these crimes. You will see forensic evidence. You'll see DNA testing to identify the body of Tylee. You'll see DNA testing that showed DNA from Tylee was found on at least 2 tools in the defendant's shed. You'll hear digital evidence dealing with geolocation data tied to certain phones that were used in this case. You'll hear from Hawaii law enforcement about searches they performed in Hawaii on the defendant and his
If
wife.
he had a little bit of a better presentation,
You will hear
this wouldn't be so
of
bad.
this defendant's
and a lot of
own
his
words.
material isn't bad. It's just that his actual delivery sucks.
You'll hear, excuse me, recorded phone calls between him.
I mean, you will hear this evidence, you will hear this evidence, you'll hear this evidence. That's great.
You'll read multiple texts. that he
And some of his
removed
earlier
sent
stuff
back.
was good too. It's just his delivery is
Another text.
balls.
Chapter 9, what's unwritten. The defendant stands before you today charged with multiple crimes. First-degree murder for the death of Tammy Daybell. First-degree murder for the death of Tylee Ryan. First-degree murder for the death of J.J. Vallow. Conspiracy to commit murder of Tammy Daybell. Conspiracy to commit murder and grand theft by deception. The death of Tylee Ryan. Conspiracy to commit murder and grand theft by deception for the death of J.J. Vallow. And insurance fraud. Two dead children buried in this defendant's backyard. The next month, his wife dead in their bed. 17 days later, this defendant marries Lori Vallow. Members of the jury, days or probably weeks from now, when the evidence in this trial is fully unfolded, we will have the opportunity to speak with you again. And at that time, we will ask you to end this horrible narrative. Your verdict will be the link that writes the final chapter of this tragic saga. A chapter that delivers justice for Tammy, justice for JJ, and justice for Tylee. Thank you.
3 out of 10 at best, and that's only because of the writing was good. If you know, there was material
Thank
there.
you, Mr. Wood, that will conclude the opening statement of the state. Mr. Pryor, a couple of questions. First, is the defense going to give an opening statement now or defer until later? And second, if you are going to give an opening statement, would we take a mid-morning recess or go forward?
Judge, could we take a short recess? And I have a statement to speak.
Okay, I think this is a good time then for our mid-morning break. We'll go ahead and take that now. And then once that's concluded, Mr. Pryor can give us a bank statement to the events.
All right.
Uh-huh. Okay, well, that was exciting and stupid. All right, so how far ahead do I have to skip to get to whatever else they're doing? All right, so let's see. Oh, it just go live? Great. All right, so we're caught up in real time. Outstanding. All right, so we've caught up. Great. Yeah, 3 out of 10 at best. The writing was fine. There were a lot of themes in there that made sense. The organization, although the chapter headings, I was like, okay. So yeah, 3 out of 10. There was things workable in there, but the presentation was just so incredibly flat. No vocal intonation. He had the pictures of the people up on a screen. I probably would have gone for physical exhibits, to be honest, rather than putting them up on a screen. I think it would have been more effective. Bad vocal intonation, bad spacing, bad vocal variety. He says zombies. He's like swallows it. He doesn't emphasize anything. It's just all flat and uninteresting. I didn't retain anything at all. It just felt boring. And I'm like, what are we talking about? I don't, it's just, yeah, it just didn't really work on any level. His movement around the courtroom, completely unplanned. It's just wandering, you know, just wandering, looking at places for no particular reason. I get the strong sense he didn't practice at all. So yeah, I had problems with that opening. So yeah. There were a couple times where there was an adjective or an other word choice that showed that someone had put some thought into the words. To my mind, like there were a couple times where there was a particular evocative word that seemed very deliberate, but he didn't deliver it with any evocation, so it didn't matter. So it was, yeah. I remember back when we used to do debate, we would practice the speeches like crazy, and we would often like find a corner of a room somewhere and just recite the speeches to ourselves in the corner of the room very softly. It looks like the workings of a madman. You know, you got all these kids that are like in a corner somewhere, staring at the corner and just muttering to themselves because they're practicing. And it's like, you could do that. Walk around. I used to walk around the building I used to work in when I was doing Toastmasters or things like that. And I was preparing speeches, and I just walk around the floor reciting the speech because it was practice. And, you know, that's one of the ways you do that, right? It's just, you just, yeah. So good times. Yeah. Since the jurors don't know much about the case, triple murder and zombies could have really gotten them engaged. Yeah, I don't think that this was doing anything for the engagement, it seems to me. Yeah, so there's a lot of different ways to practice speeches. And it's also the way I used to memorize speeches, just by delivering them over and over and over again, right? So I would print them out. And sometimes I used to do it on 3x5 cards, like print out segments on 3x5 cards. Sometimes I'd do it that way. And I just memorize it by giving it over and over and over and over and over. And also you rewrite when you do that, because how you write and how you deliver can be a little bit different, right? So as you're actually doing it, you start to change it up a little bit. And so you memorize something, at least in my experience, you memorize something slightly different than you wrote down, but that's okay, because that's part of the exercise of learning. And then you get up and you give the speech, and it's fantastic because you're prepared. And that's how, when I did Toastmasters, I used to win club competitions all the time, area competitions all the time. I got pretty far in regionals quite a lot because, you know, I know how to do this. All right, so what does the defense have for us? Hopefully nothing that makes me want to die inside. I facilitate medical lectures, so sometimes it's like this guy, but the good ones don't change in tone. Well, yeah, every CLE is like this, at least in my experience. Every continuing legal education is a pile of absolute boredom. And then there's no delivery. I have yet to see a continuing legal education that doesn't make me want to die inside. So, yeah. You made it to state finals? Yeah, I made it for state finals in various contexts before. Sure. It's been a while since I've been Toastmasters. I should definitely get back into it. I need to figure out where. I need to figure out, like, when I would do it. Presumably sometime in the evenings, I guess. And so I need to find an evening one somewhere. I miss formalized debate. I miss speech and debate, I have to say. I miss going to tournaments. I miss the camaraderie of that. I miss it.
All rise.
What's Toastmasters? It's a public speaking group. The word toast is, toasting somebody, to give a speech. Toastmasters is a public speaking organization. It's a place where you go to practice public speaking. That's what they do. It's fun. I recommend giving it a shot.
Very present and accounted for.
All right, thank you. Please be seated. We've concluded our morning recess. We're back on the record on KCR 22-21-16-23, State of Idaho versus Chad Daybell. This is the time we'll next have opening statements by the defense. Mr. Pryor, is the defense ready to proceed?
Yes, Your Honor. May I have the post permission to enter the well?
You may.
Thank you.
Okay, yeah, so we asked for permission to enter the well. Fair enough.
I'll make sure it is working. Okay.
Good morning, ladies and gentlemen. As an introduction, I'm John Pryor. I'm the defense attorney for Mr. Daybell. And I'm from Meridian, Idaho. I'm an attorney from Meridian, Idaho. We're here on the west side of the state. I want to talk to you a little bit today. And at my age, video presentations are not something that would come easy to me. So I'm just going to talk to you a little bit about my view of the case and the facts and evidence.
Right.
What's important are facts and evidence. I think that when we went through the jury selection process, we talked about facts and we talked about evidence. And the judge gave you an instruction to talk to you a little bit about you take into consideration the facts of this case and not be distracted by other things. Don't be distracted by speculation. Don't be distracted by guesses or assumptions or hunches. It all comes down to facts and evidence. So I'm going to talk to you a little bit about the facts and evidence in this case. Chad Daybell, I'm learning this, and I've had some time to learn about this because it didn't come natural to me. But Chad Daybell went on what's called a mission early on in his life. And I guess what a mission is, I'm not familiar with that, but I guess what a mission is they go away to a location and they talk to people about their religious beliefs. And Chad's faith, that was important as part of his faith. And when they return from these missions, they start the process of moving on with their lives. And when Chad got back from doing his mission in New Jersey, he met Tammy Daybell. Another fact that I discovered, and you'll hear a little bit about, is that Chad had an extended engagement, had an extended by his faith standards romance before they got married. Chad and Tammy dated for approximately 6 months. And what I understand is by their nature, 6 months is an extended dating process before you end up getting married. So after 6 months, they got married. They were married in Utah and proceeded then to have children. They had 5 children, now all 5 adult children. At some point, they moved back here to Idaho, or moved to Idaho, and they started a small publishing company. And you'll hear testimony that the publishing company was predominantly run by Tammy. Tammy managed it. Tammy was the brains behind the company. And Tammy basically took the reins and did everything that was necessary to move this publishing company. It was a small publishing company, a very small publishing company. And what they did is basically publish books. Chad would write these books. And he would write these books about his religious experiences. In his faith, he had certain beliefs, faith that he practiced. You know, when he went on his mission, when he, read his interpretation of the books that he used for his faith, he started writing books about things that were consistent with his faith. Things like premonitions. We've all heard of premonitions, about being able to predict things, about being able to see maybe when things happen. And some people believe in that, some people don't. Some people have personally experienced that, or I've been here before. But he writes about his premonitions. He writes about good and evil, and what it means to be good, and what it means to be evil. He writes about dark and light. He writes about subjects that are a little darker, like death, and maybe the coming of the end of things, and when his Savior in his mind is going to come back, and maybe there'll be some kind of a redemption of some sort. But his books covered a lot of subjects like that, and they were all based on fiction. In other words, he was writing these books about theories and things that came into his head, and he would write these stories. But he also wrote children's books, and he wrote books for teenagers, and he wrote these books about adventures and then some crazy ideas about things that kids and teenagers get involved in. In about October of 2018, Chad was going out and he was invited by one of the witnesses that you'll hear in this case to speak about his books. And this was not uncommon. He would travel and he would be asked to say, well, come and talk about some of the things that you believe in. We've talked about these premonitions, life experiences. You're going to hear testimony about that. And he was invited on one particular occasion in late October. And he attended this, and while he was there trying to sell his books, and like most of us who are business people, the focus of these meetings really was for Chad to try to get his books published, because that's how he made a living. And he was there in one of his booths trying to promote his books, and he laid them out there. And this beautifully stunning woman named Lori Vallow comes up, and she starts giving him a lot of attention. And she pursued him. And she encouraged him. And you'll hear testimony that she went so far as to grab behind the booth and sort of help him in trying to sell some of his books. She obviously had an interest, and maybe she felt that he was this publisher, or maybe she had an opinion. You'll hear testimony about that. And then after the seminar, there was a length of time where there was no contact between the two of them, month and a half, 2 months. And during that time, Chad Daybell went on his day-to-day life. He'd been married to Tammy for some 29 years, has no remarkable background of any kind. I think the testimony we offer will show he had a speeding ticket in 2005. But Lori Vallow was a different story. Lori Vallow was someone who, right out of high school, married her first husband. You'll hear testimony about this. That marriage was very short-lived, very short-lived. She then married husband number 2 a few years later. And again, very short-lived
Much
marriage.
better so far.
And there's some testimony indication
He tries to humanize Chad Daybell. And now he's on to, the succubus who came into his life.
Lori's brother,
Okay.
Alex. You're going to hear about Alex Cox. Alex Cox was Lori's protector. Alex Cox would do anything and everything to protect, aid, and assist Lori Vallow in whatever her endeavors, without unbridled question, anything. And if Alex Cox even perceived that there was a problem, Alex Cox reacted. You're going to hear testimony that in 2007, I believe it was in August of 2007, Lori Vallow had finished up going through her third marriage with Joseph Ryan. It was a tumultuous, you'll hear testimony that it was a tumultuous marriage, a terrible marriage. Lori Vallow made accusations against Joseph Ryan of abusing their child, Tylee. Yes, the same Tylee. And during one of the visits in 2007, folks, and I want to tell you, you're going to hear testimony that in 2007, Chad Daybell didn't even know Lori Vallow existed. But Alex Cox, after one of the exchanges and the visitations with Tylee, Alex Cox approached Joseph Ryan and shot him with a taser and assaulted him. Was eventually charged with aggravated assault, was eventually put in jail, and had this on his record. And there was representation, the facts would suggest that at the time Joseph Ryan feared for his life. This was a serious situation. But it set the pattern for what we're dealing with Alex Cox. Whenever there was a problem or a threat to Lori Vallow, you'll hear testimony that Alex Cox came to the rescue. But Alex Cox would run without even question and do whatever was necessary to solve Lori Vallow's problems. We're going to fast forward then to 2019. Lori Vallow is still married to Charles Vallow. And the prosecuting attorney mentioned this, yes. Chad Daybell at that point, was coming in January, February, started to have communications with Lori Vallow. And yes, folks, it turned into an inappropriate relationship. 2019 forward. And yes, he was engaging in discussions, he was engaging in contact with her, all of the things that the prosecutor talked about in terms of a relationship. But subsequent to the seriousness of this relationship getting rolling, Alex Cox was at a visitation in 2019 with Charles Vallow. And Lori Vallow was there. Tylee Ryan was there. JJ was there. They were all present. And during that altercation and that supposed visit, much like with Joseph Ryan, Alex Cox took out a gun and shot Charles Vallow.
See what he did there with the pause? He got a gun and shot Charles Vallow. Pause. A little vocal intonation. Hey, has someone been practicing?
Chad Daybell was implicated in that. And you're going to hear further testimony that he was not. You're going to hear testimony and see documentation that suggests that the prosecuting attorney on review of this indicated that there is no likelihood of conviction of Chad Daybell. You'll hear testimony that Chad Daybell had nothing to do with the execution by Alex Cox, Charles Vallow. And the same for Brandon Boudreaux. You will hear that Chad Daybell is not being pursued for any involvement in the Brandon Boudreaux attempted murder. Those occurred, and those are separate, as well as the Charles Vallow. So what we have is we have a situation where someone who's 29 years old, Chad Daybell, 29 years of marriage with Tammy Daybell, no discernible issues in his life. And then Lori Vallow comes into the picture, Miss Texas, with her testimony about this beautiful, vivacious woman, very sexual person, and very manipulative. And she knows how to get what she wants. And she drew Chad Daybell into a relationship, and an unfortunate relationship, that Chad fell into. After that, things started rolling, and issues started happening, but eventually, yes, there was a murder, and there was a burial. And you've heard discussion about the backyard of Chad Daybell. Well, we have a 4.5 acre farm in Fremont County, Idaho. And you'll hear testimony that the body of J.J. Vallow was discovered behind an irrigation pond and a tree out in the pasture. So technically, yes, maybe the backyard, more accurately described as the pasture, hidden behind a tree. You're going to hear testimony that also in the middle of this pasture was a raspberry patch, former raspberry patch, that was then turned into a place for them to bury the cats, the dogs, and all of the animals on the farm. Okay? Again, out in the pasture of the field and not the backyard. You hear testimony about that. You're going to hear from 4 experts that I'm going to bring forward. And these 4 experts, the first one is going to be Dr. Greg Hampikian. And Dr. Hampikian is a bit of a notable local of Boise State University. And Dr. Hampikian is a DNA expert, considered one of the best DNA experts. He's been involved and has significant work that he's done on both the defense and for the prosecution. He was involved and led the team with Amanda Knox in Italy that got her exonerated because of the DNA evidence. He has substantial experience. And anybody or anyone who knows anything about DNA goes to Dr. Hampikian first, because he is the guy. And Dr. Hampikian is going to talk a little bit about the DNA evidence that's found on the scene. Dr. Hampikian is going to talk about the fingerprint on the plastic that J.J. Vallow was discovered in, was that of Alex Cox. Dr. Hampikian is going to talk about the hair sample that was found on the plastic.
He's going through what the witnesses will hear or what they'll say.
Dr. Hampikian is going to talk about several, and I mean several other hairs that were found on the plastic of J.J. Vallow. But he's also going to say that there was no DNA evidence, no hair sample of Chad Daybell on Tylee Ryan or on J.J. Vallow. You're then going to hear from Dr. Raven. Dr. Raven is a forensic pathologist, and she's going to talk a little bit about the circumstances surrounding Tammy Daybell. And what Dr. Raven is going to say is that there's no indication that this is either a homicide or any other crime, and that the only conclusion she can come to is you can't determine what the cause of death was. There's no way to determine it. Tammy Daybell was buried. You'll hear testimony about that. And then a short time later, the police officers showed up and they dug her body up after she'd been buried, after she was laid to rest, and then continued after the body was pulled out of the ground and continued to examine it for whatever they were looking for. And what you're going to find is based on that, Dr. Raven's going to say you can't determine what the cause of death is. You're going to hear testimony from the Daybell children, from the children themselves, 4 of the 5 children, I think, 3 or 4 of the 5 children. They're going to talk about their mother's health struggles. They're going to talk about their mother's use of various medicinal treatments that she would use, oils that she would put on her leg, medicine and different herbs that she would take, and that her mother was suffering from, a number of maladies, and that she would refuse to go see a doctor or get it treated.
A little too matter of fact.
Dr. Raven's going to enlighten you a little bit about some of the circumstances regarding Tammy Daybell. You're then going to hear from Patrick Eller. He's
See, that would be the example of signposting that's not obvious.
And Patrick Eller,
right? I am moving on to another subject. How do you know that? I'm now going to talk about something different. You are now going to hear from this person. Oh, that would be an example of signposting that isn't right in your face. What amazing. Instead of saying chapter 6. Oh my God.
Records that are involved in this case. He's going to specifically talk about the travels of Alex Cox, because you are going to hear testimony that Alex Cox went to Chad Daybell's property on the 9th of September. You're going to hear that Alex Cox approached Chad Daybell's property a half a dozen other, 5 or 6 other times. You're going to hear testimony that Alex Cox was there on the 23rd. And you're going to hear where Alex Cox was in a number of other times and places in his whereabouts and his travels for about a 2.5 month period. And Patrick is going to, offer you some information and data to support all of that. And finally, you're going to hear from a forensic anthropologist. And his name's Eric Barlow.
See, finally, you're going to hear from a forensic anthropologist. Hey, I'm changing subjects. As opposed to Chapter 7, the forensic anthropologist.
The remains of Tylee were burned. Eric Barlow is going to talk to you a little bit about the lack of complete skeletal remains and why, when Tylee was dug down the ground, there was not a complete set of skeletal remains. In fact, there were a number of pieces of that were missing. You're going to hear a lot of evidence, and the judge has talked to us a little bit about not making a decision until you hear all of the evidence. And there's a specific jury instruction that talks about that. The jury instruction is, consider all the evidence. Listen to the instructions from the court on how you're to proceed. Listen to the arguments of the prosecuting attorney and the defense, and then and only then do you make your decision. And at the conclusion of all that evidence, and at the conclusion of the judge's instructions, the arguments of both of the defense attorneys, I'm going to ask you folks to return a verdict not guilty. Thank you, folks.
All right. Not bad. Okay. Especially by comparison, right? I mean, it's like a 5 or 6 at best, but hey, still light years ahead of the prosecution. Makes me want to rescore the prosecution to be like a 2. He's okay. It's like 5, maybe 6. It's fine.
Your Honor, the state is prepared. We had spoken with your clerk earlier without we going to have a brief sidebar.
Oh, let's discuss our schedule with the sidebar. Sure.
At least it was competent. The microphone in the hand doesn't help. I don't know if there's a way around that logistically, but having something in your hand like that is not helpful. But acceptable. Acceptable. You will hear from this witness. He'll talk to you about these things. Then you'll hear from this witness who will talk to you about these things. And then you'll hear from this witness. Finally, you'll hear from this witness. And then he gives the sort of the cautionary notes like, remember to keep your mind open and, listen to all the evidence, because implicitly, although he doesn't say it, implicitly, although I might say it explicitly, to be honest, in this circumstance, I might actually say it explicitly. Implicitly because, the evidence is going to sound really, really bad at first. I might figure out a different way to say it, obviously. But I might say it more explicitly. But, keep your eyes open because, we're not going to be able to talk to you for who knows how long. 5 weeks or something. All you're going to hear from, for the prosecution, one would assume they're roughly even split, although who knows. But, you're not going to hear from us for another 6 weeks or something. So you have to keep your minds open through a lot. It's like, okay, fair. Fair. Wireless mics would be nice, yeah. Like, is there any other solution to this other than a handheld mic? Can I use a lavalier? Even if I had to use a lectern, I probably would pick that. But yeah, having in my hand, and he wasn't like wandering around completely aimlessly. He had vocal variety, he had pausing. He actually looked up at the jury instead of just looking in random directions sometimes. Yeah, the prosecution deserves it too. The prosecution deserves that too. The only reason they get 2 points really is because of the writing. The actual delivery. Yeah. But the writing was good. For the most part. Thank you, Time Lady, for becoming an uncivilian for 99 cents. We do appreciate everyone who hits that beautiful, beautiful join button. Paula and Green-Eyed Southern Girl and Tom and Katie. You also could hit the join button for 99 cents and help to support the channel. I'd appreciate it. It helps to keep the channel going and helps to show your support and love. So if you would be so kind as to hit the join button, I would really appreciate it. Thank you. Yeah. You're a member through Amazon? You might well be. It wouldn't show up on YouTube, but you might well be an Amazon member. So if you're an Amazon member, then fair enough. And we appreciate that you are subscribing through Amazon. That's very kind of you as well. Thank you, Dees, for being a member for 18 months. Yeah, so if you have Amazon Prime, just a friendly reminder that you can subscribe, which is the paid option on Twitch. So it would be the equivalent of hitting the join button. But if you have Amazon Prime, you can do it for free. And right now, 35 of you are doing that. And if the rest of you would do it, it'd be helpful. Just a friendly reminder, it does expire every month. You have to manually renew it every month. So set yourself a calendar reminder or something. Thank you, Kate, for becoming an uncivilian for 99 cents.
Yes, Your Honor, the state will be calling later to see it.
All right, well, call your witness, we'll have him come up and sworn.
Sir, before safely.
Put a calendar reminder on your Amazon, that'd be great. Thanks.
Please, Madam Clerk, raise your right hand and be sworn.
Solemnly swear or affirm the testimony you're about to give will be the truth, the truth, and nothing but the truth, so help you God.
All right.
Life's not too bad, man. Life is not too bad.
Sir, as you testify, just remember to make a audible response to anything that being questioned, so the record stays clear, and try to avoid speaking over the top of anyone questioning you. And then what you'd like to inquire in that.
Thank you, Your Honor. Officer, will you state your name and spell your last name for the record?
Ray Hermosillo, Hermosillo. Is that on?
Your Honor, is that microphone on?
I'm not sure.
More microphone problems. How's the new place? New place is treating me pretty well so far. So far, so good. I've been here just about a month, and I'm digging the new digs. It's been beneficial.
Go ahead and start over and just talk right into the mic, please.
Detective, will you state your name and spell your last name for the record?
Ray Hermosillo, Hermosillo.
Thank you. Detective Hermosillo, what is your occupation?
I'm currently a lieutenant in the detective division for the Rexburg Police Department.
How long have you been a detective?
5 years.
And how long were you involved in
I haven't found an
enforcement
improv
before
group
you became
yet.
a
I thought I
detective?
found one, but I wasn't able to get in. So I still need to do more research on improv groups.
18 years.
Thank you, green-eyed Southern girl,
Have you
for
worked
becoming
for
an
another
uncivilian
law
for 99 cents.
enforcement agency
It
other
is
than the
appreciated. Thank you.
No,
And are you post-certified?
I am.
Detective, have you been involved in the case regarding Chad Daybell?
Yes, I am.
You know what Chad Daybell looks like?
I do.
Is he present in this courtroom?
He is. He's at the defendant's table, for sure, in our low screen time.
Thank you. Detective, let's talk about how did you initially become involved in the investigation regarding Mr. Daybell?
On November 1st, 2019, I was contacted by Fremont County Sheriff's Office. I was told that there was possibly a Jeep that was involved in an attempted homicide in our jurisdiction. So at that time, with that information, I contacted Gilbert Police and asked what they needed us to do to assist them.
What did you do?
Gilbert Police asked us to seize the Jeep if it was located. They gave us the address of 565 Pioneer, which is Rock Creek Townhomes. Yes, also asked
I'm
us
going to stop real quick. Where is that address located? What city?
Rexburg,
What county is Rexburg in?
Madison County.
Thank you.
So once you received that address, what did you do?
Gilbert asked us to.
Gotta remember to establish venue.
They
So,
also
might as well
asked
get
us
it
to
done early.
perform intermittent surveillance. So at that time, that's exactly what we did.
When you say intermittent surveillance, what did you do to perform that surveillance?
When we were driving around, when there was no more calls coming in, we would park in front of the residence, behind the residence, take photographs of anybody leaving or coming in. That's basically what we did for the surveillance.
And do you recall what dates you did that surveillance?
The dates were between November 1st and November 4th, when I located the Jeep at 565 Pioneer.
Did you ever see the defendant at that address?
I did. There were a few times during the intermittent surveillance that we had taken photographs of the defendant, Mr. Daybell, and Lori Vallow, either coming or going from the residence.
And that was between the dates of November 1st and November 4th.
Judge, could we, for the record, have this officer established?
I'm sorry, 2019.
Right, and did you, when you talked about seeing Mr. Daybell, was that between those dates of November 1st and November 4th, 2019?
That's correct.
And your primary job was to look for a Jeep, is that accurate?
Yes, that's correct.
Your Honor, I'm going to ask witness B. Ann what's been marked, the State's Exhibit 90. Very well, the court has a courtesy copy and counsel as well.
Let me see if I can find out the name of the first witness so I can put it on screen.
Mr. Wood, clerk, it sounded like you said 90. This is 9A.
Well, I believe it's 90. I have to double check.
I just see the exhibit, so I can confirm my words. It's okay.
You're correct, Your Honor, 9A. You said one. And that would be exhibits 9A through 90. Detective, do you recognize State's Exhibits 9A through 90?
Yes, I do.
What do they report to be?
That is the Jeep that I had seized from my parked in the parking lot just outside of 565.
Right. And were these pictures taken at the location of 565 Pioneer?
No, these photographs are taken.
No one seems to have it.
At the police department.
Right. Did you take these pictures?
I did not.
But do you recognize these images as true and accurate representations of the Jeep you seized on 565 Pioneer Drive?
Yes.
Your Honor, I'd ask.
Yeah, no one seems to have the name of the witness.
Evidence.
The objection from the defense.
Judge, I'd like to move on to your immediate action on the foundation.
9A.
All right, you can go there or ask foundational questions, Mr. Pryor.
Officer Hermosillo, we move on to your immediate. You mentioned
Okay,
that
I
you
got
were
it.
doing surveillance on the Jeep.
I got it.
That's correct.
Did you have an occasion to get close to the Jeep during that surveillance?
We hadn't located the Jeep during that surveillance. I located the Jeep on November 4th, 2019, and that's when I had it impounded.
Okay, and at the time of being impounded, did you have the occasion to go through the Jeep and observe the Jeep energy? Or were you relying just on the photographs taken in the Jeep? Do you understand my question?
No, sir.
I'll rephrase that. Did you have a personal occasion to go through the inside of that Jeep and observe the contents within the Jeep?
Your Honor, I think that goes beyond the scope of this specific exhibit.
I guess the issue, Mr. Wood, is he indicated he did not take these photographs, and some of the exhibits also contain photographs of the interior of the Jeep, so it's proper or dire negative objection.
Thank you. May I continue, Judge?
Yes.
Officer, all I'm trying to establish is I don't want you to be able to testify that,
There we go.
Someone else took the pictures and this is what they found. I want you to be able, you're authenticating and you're under oath to swear that these are accurate photos. I'm trying to find out if that knowledge is based on your personal experience, or is it simply based on the fact that you're relying on somebody else who told you this is what we found? So that's what I'd like you to clarify for me, if you would, sir.
Sure. I impounded the Jeep. I was standing next to the officer taking the photographs, and I also went through the Jeep personally.
Okay, I withdraw the objection. Thank you, officer.
All right, exhibits 9A through D.
I impounded the Jeep. I was standing next to the officer.
to the jury.
You may want to have a quick sidebar with counsel.
About the reporter.
Have I actually gone to trial? Yes, I have on 2 occasions. We're in sidebar land. Yeah, trials are annoying. Appeals are much more to my taste for a lot of practical reasons. While we're waiting, I'm going to see if I can make a little bit more of an exciting thumbnail. I'm just going to try to do a big face of Chad Daybell and try to make some fonts here. And Lori, the trial was so clear I take audio only over this. Well, we do we do what we can, man, you know. See if we can make a more attractive thumbnail. Don't like the silence? We do what we can. I've cleaned up the audio as much as I can on my end by adding noise reduction and things like that, so we do what we can, but, you know, there's only so much you can do with what you have.
All right, Mr. Wood, if you'd like to proceed with publishing the court's instructions there on the sidebar, then you may publish any or all of the photos.
Thank you, Your Honor, and if I could have access to the
Let's see if we can find a different image of him that I want to use. Oh, I'll use this one, I think.
Detective, is this what you saw on State's Exhibit A?
Cleaner.
Yes,
Is this the Jeep that you had been assigned to do surveillance for?
that's right.
Did you ever learn who this Jeep belonged to?
I did.
Who did it belong to?
It was registered to Charles Vallow, but we later determined that Tylee Ryan drove that Jeep.
Detective, this is State's Exhibit 9B. Is this that same Jeep?
Yes,
That's all I'm going to publish, manager. All right, thank you. Detective, while you were doing your surveillance, you testified that you had occasion to see the defendant, Lori Vallow. Did you ever see children with her?
but we did.
You do more than grow
Did you
potatoes?
ever see
Apparently,
anybody
you
else?
also have cult murders.
No.
So, yes, the potatoes and the cult murders. You're a very diverse state.
Were you, at that time, were you aware of who J.J. Vallow was?
No,
Were you aware of who Tylee Ryan was?
no.
We have not developed a side story for this
So
trial
when you
yet. That is still something to
Is
happen.
it fair to
But
say
we don't
that
need to
when you
rush
were
it,
initially contacted
right? It's something
by
that will
other
appear
law enforcement agencies,
organically.
they did not ask you to look for those children at that time?
That's correct.
Detective, did your role in this investigation change after that?
It did.
When did that happen?
After I had seized the Jeep November 4th, 2019, I contacted Gilbert Police and let them know I had the Jeep. Gilbert Police Department flew to Rexburg with a few of their detectives and a few of their crime analysts to go through the Jeep and circle one of the Jeep. They were looking for the infotainment center, which is the middle of the Jeep console, has the GPS locations, things of that nature, and they wanted the information extracted. So when they were up here on November 18th, 2019, they asked me and the other detectives if during our intermittent surveillance, if we had seen any children. And we told them we hadn't. They stated that JJ's grandmother.
Judge, I'm going to object. I'm trying to be somewhat open-minded about foundation, but I'm going to object.
I'll ask a question, Your Honor. Go ahead, please. So you did have further contact with law enforcement from Arizona?
All right. I got a better picture of Chad
Which law
Daybell.
enforcement agency was that?
Gilbert Police Department.
And was it Gilbert Police Department that was looking for that Jeep?
Yes, it was.
When you followed up with them about the Jeep, did they give you any other information about their case?
They did.
Did any of that information regard children?
Yes, it did.
What were you told by Gilbert Police?
Judge, objection, hearsay.
Coming in for the effect on the listener, Your Honor?
Judge, can we approach?
No, give me a moment to make a ruling on that.
Okay, cool.
I'll start, the witness can answer the question, but for only the purpose of effect on the listener, if you can clarify that through the case, Mr. Wood. Sure. And any objections overruled.
Detective, based on your conversation with Gilbert Police, did you take any action regarding any children involved in this case?
Yes, we did.
And for the purpose of what you did, what information were you given that you needed to look up on?
We were informed through their investigation that JJ Vallow's grandmother was concerned for his safety.
Judge, and again, I'm going to object at this point to renew my objection. That's going beyond.
I'll also say that as bringing up her stance to
Okay. Based on your conversation with Gilbert Police, what was the next step you took in your investigation?
We were requested to do a welfare check on JJ Vallow from the Gilbert Police Department.
Detective, had you ever met JJ Vallow?
No,
Were you provided any identifying information as to his age or where he might be?
we were provided very little information, just a brief description of what he looked like, his age, and where he should be, which was 565. Sorry, 565 Pioneer Road, where he lived with his mother, Lori Vallow.
Your Honor, I'm going to ask that the witness be handed State's Exhibit 1.
Judge, I'm going to stipulate to the admission of State's Exhibit 1.
All right, it's being offered, Mr. Moore.
Yes, Your Honor.
State's Exhibit 1 has been offered without objection. The court will admit State's Exhibit 1.
And Your Honor, with that stipulation, I'd actually ask that the witness be handed State's Exhibit 2 and State's Exhibit 3 as well.
Further stipulate to State's Exhibit 2 and stipulate to State's Exhibit 3.
Very well. Then, presuming you're being offered, State's Exhibits 2 and 3 are also admitted. And just what if they're going to be published again, the same issue we discussed before, please.
That's all I'm doing. Thank you. Detective, can you look at State's Exhibit 1? What is State's Exhibit?
That is a birth certificate out of the state of Louisiana.
Your Honor, where this is, may I publish?
Yeah.
That's not bad.
Detective, can you identify who this is a birth certificate for?
The name on my birth certificate is Kanan Todd Trahan,
What is the birth date?
May 25th, 2012.
And where is the place of birth?
Lake Charles, Louisiana.
Your Honor, if I may publish State's Exhibit 2.
Yeah.
Detective, I'm going to ask you to turn to the second page of State's Exhibit 2.
Yeah, gotta set that reminder, man, Paul. Gotta set the reminder so you'll remember to resub. I know.
Detective, what is State's Exhibit 2?
It's a decree of adoption.
And reading through that, are you aware of that as a decree of adoption for?
Yes,
Who is it for?
Kanan Todd Trahan.
And on the bottom of that, can you read the second to the bottom paragraph? That here,
The entire paragraph.
yes, please.
It is further ordered, the judge can decree that the name of the child, Canaan Todd Trahan, be changed as follows: Joshua Jackson Vallow, and the registrar of Louisiana Department of Health and Statistics is hereby ordered to make the appropriate changes in his records.
May I have other states exhibit 3 now?
Yes.
Second, what is states exhibit 3?
That is also a birth certificate from the state of Louisiana.
And who is the birth certificate for?
Joshua Jackson Vallow.
Second, in the course of your investigation. In the course of your investigation, have you learned what Joshua Jackson or JJ Vallow looks like?
Yes,
Have you seen pictures of him?
yes, I have.
Were you able to access pictures of him from iCloud accounts associated with his mother?
Yes,
Your Honor, I asked that the witness be handed states exhibit 4.
All right, the witness is handed states exhibit 4.
Detective, you testified that you never met JJ Vallow, correct? How did you come to know what he looked like?
through photographs we were given.
Where did you get those photographs?
We received a few from Gilbert Police. His grandmother, Kate Woodcock. I think that's all I can remember.
And I spoke with you briefly before. Did you ever have occasion to review iCloud accounts belonging to Lori Vallow?
Yes, we did.
And on those iCloud accounts, did you find other pictures of JJ Vallow?
Yes, we did.
And did you find videos of JJ Vallow?
Yes.
Based on your investigation, what does exhibit 4 report to you?
Photograph of JJ.
And you didn't take this picture, correct?
Correct.
But you recognize that individual as Joshua or JJ Vallow?
Yes.
Your Honor, for demonstrative purposes, the state would move to admit the state's exhibit 4.
The objection. Judge, there's a little bit of foundation that I want to iron on. So what's the source of that picture?
Lori's iCloud, Lori for Style, iCloud.com.
Judge, can we approach just briefly on this issue?
Just trying to find the right font right now for this text box. That one works, I think. Yeah. And dings, I don't think that's gonna. I don't think that's a winner. I don't think that's a winner, man.
based on our sidebar with counsel, I understand the defense does not have an objection at this point to Exhibit 4 being submitted. Is that correct, Mr. Parker?
Yes, Your Honor.
All right, Exhibit 4 then is submitted.
Your Honor, may I publish to the jury?
Yeah.
Detective, who is that?
That's J.J. Vallow.
Detective, you were talking about receiving a request to do a welfare check, correct?
That's correct.
When did you receive that request?
On November 25th, 2019, in late evening hours, I received a call from Detective Pillar of the Gilbert Police Department. And he requested that the judge, I'm going to object at this point.
The request is a hearsay.
At this point, I don't hear an objection on hearsay, so you see.
Go ahead and read the question.
All right, let's try this
In response
background.
to that request.
On November 25th, 2019.
All right, let's give this a
I
shot.
received a call from Detective Pillar of the Gilbert Police Department. He requested that I do a welfare check on J.J. Vallow the next morning because he wasn't able to get a hold of J.J. or J.J.
That was the same as you're saying.
Did you do a welfare check for J.J. Vallow?
We did
What date did you do that?
November 26th, 2019.
How did you go about doing that?
On that morning of November 26th, 2019, myself and Detective Daybell went to Lori Vallow's residence where we presumed JJ was at. She lived at 565 Pioneer, apartment 175. As we approached, expecting to speak with Lori, we noticed the defendant, Chad Daybell, and Alex Cox unloading a pickup truck near the garage area.
And at this point, were you aware of who Chad Daybell was?
Yes,
How would you learn about him?
through our investigation with Gilbert and communicating with
What
Gilbert
just
Police
happened?
Department.
And so you recognized who he was.
Correct.
And at that time, were you aware who Alex Cox was?
Yes, we were.
So after you saw them, what did you do next?
I got out of my vehicle and made contact with Alex. He was standing in the driver's side of his pickup truck, and the defendant Daybell was on the passenger side. I asked Alex if Lori Vallow was home, and he stated that she wasn't home. I asked Alex if JJ was home, that we were there to do a welfare check. And at that point, Alex got a surprised, frightened look on his face, looked over at across the pickup at the defendant Daybell. The defendant Daybell then looked back at Alex. And initially, neither one of them answered my question.
After they didn't answer your question, what did you do?
I asked them again if JJ was home, and Alex Cox finally answered and stated that JJ was with his grandmother in Louisiana.
When you were given that information, did it cause you any concern?
It did, because I informed Alex that it was highly unlikely because his grandmother.
Judge, I'm going to object at this point. We're going to be getting into super soon.
I'll sustain that.
Your Honor, I think the defendant's about to testify what he said to Alex Cox.
Okay, that's not what I understood where it was going. You can ask the question, Mr. Wood.
Detective, what did you say to Alex Cox?
I informed Alex that it was unlikely because Kay.
Judge, I'm going to object. This is going to lead into hearsay.
Your Honor, this is a statement by a declarant on the witness seat. It cannot be hearsay.
overruled, and it is permissible, so objection overruled.
What did you say to Alex Cox?
I informed Alex that it was unlikely that JJ was with his grandmother Kay because she was the one who called in the welfare check.
And what was the response to that?
There was no response initially. But Alex again looked over at the defendant Daybell, and they kind of both just looked at each other. And at that point, I asked Alex where I could find Lori Vallow.
And did he give you a location to find her?
He stated that she was in apartment 107,
All
which
right.
is the same apartment complex, just a few apartments down.
What did you do at that point?
At that point, I asked Alex if there was a way I could contact Lori and asked Alex for her cell phone number. And Alex told me that he didn't have her cell phone.
So were you aware at that point that Alex Cox and Lori Vallow were siblings?
Yes, through our investigation with Gilbert, we knew that Alex Cox and Lori Vallow were extremely close. So when Alex told me he didn't have a sister's cell phone number, I assumed he was lying to me.
What did you do once you received that information?
Myself and Detective Hope left the defendant Daybell and Alex in the pickup truck. We went over to apartment 107 to see if we could make contact with Lori. At that point, we were just trying to find JJ Vallow.
And were you able to locate him at apartment 107?
No, we knocked on apartment 107, there was no answer. So at that point, Detective Hope began knocking on neighbors' doors to see if we could get a hold of anybody who would know if they saw a little boy coming in or out of that apartment or who resided in that apartment. And while Detective Hope was doing that, I started walking back to my vehicle to call for more detectives to come over to our location.
Why did you call for more detectives?
Because of the deception from Alex, I wanted to figure out what exactly was going on. And we were going to start canvassing the area and knocking on doors, so the more detectives we had on scene, the better.
All right, you guys can help me with a little bit of thumbnail selection. How about
Can you
that?
clarify, when you first saw Alex and Chad Daybell, did you speak with Chad Daybell?
No, I personally didn't.
So I believe you testified that you started walking back to the original defendant. What happened then?
As I was approaching my car that was parked in the alleyway, I noticed the defendant Daybell driving towards me in a black Chevy Equinox.
All right.
It appeared he had just left apartment 175.
Trying to go for a
and
more
said towards me in
clean
the alleyway.
thumbnail
So at that point, I
design.
stopped him to have a conversation.
What did you ask him?
All right, what do we think?
I asked the defendant Daybell, when's the last
Do we
time
like
you
the
saw
fonts
J.J.
here?
Vallow?
I think it looks okay, but I'm not so sure about the font.
In apartment 107 was Lori Vallow.
Did you ask him anything else?
I did. I asked him how he knew Lori, and he stated he had only met her a couple of times.
No,
And that he didn't know her.
no.
Did that response cause any concern for you?
It did.
Why?
That's not bad.
Through our investigation, prior to me making any contact with
This particular
the
font is
defendant
called
Daybell,
Archivo Black.
we knew that Alex, Chad, and Lori had been married 2 weeks prior to my conversation with them now.
Should we just try good old Times New Roman?
So it's fair to say you were troubled by his. What happened after?
I asked Mr. Daybell.
What's that for Gothic?
Daybell, He had Lori Vallow's telephone number, so I get over. And he stated he didn't have her phone number.
Did you have
Ariel?
a conversation?
I did. When I was speaking with the defendant Daybell, Detective Hope saw me talking with him and started to walk back to my location. As he approached, I again asked the defendant Daybell for Lori's number because I assumed he was lying to me based on what I knew. And at that time, he did give me Lori's.
Ariel, no. Ariel Nova, no. Ariel
Did he tell you why
Unicode,
he didn't
no.
give it to you in the first place?
No.
He did. He
No.
said that he felt I was accusing him of something.
And had you accused him of anything?
No, I simply asked him for whereabouts of JJ and asked him for his
McGarmont,
wife's phone.
no.
Detective, during this interaction, we were in a body cam.
No,
All right.
Why not?
I think Archivo is pretty good.
in the detective division, most of our interviews are in a controlled environment.
Calibri?
We call the police department. We have an interview room set up with cameras. So most of the time we're conducting our business and our interviews
Calibri?
at the police department. It's very
No.
rare we're the first officers or detectives on scene. There is one body cam between 7 detectives. Unlike patrol, where a patrolman is assigned a body cam, a detective is not assigned a body.
What happened after you got that information from the defendant?
I called my lieutenant at the time and told him what was going on. I felt that based on the deception and lies from the defendant Daybell, who is JJ's stepfather, the lies and the deception from JJ's uncle, who is Alex Cox. I felt there was more going on with the whereabouts of JJ. And so at that time, I wanted to get everybody over there to see if we could figure out
I'm
what
gonna
was
make it
going
go
on.
closer.
So
I
I
can
asked
ungroup it.
my lieutenant to gather some detectives and respond to my location.
And then what happened?
A few minutes later, my lieutenant arrived with Detective Dave Stubbs, who had a body cam at that point. We began knocking on doors. We went back to 175, which is Lori Vallow's apartment, and started knocking on her door. We didn't get any answer.
And I apologize if I missed it. Who was your lieutenant?
Ron Wall.
Font should be cohesive. You think it should be the same font
And so
throughout?
after you weren't able to get any answers, what did you do next?
Through our investigation, we learned that Lori Vallow's niece, Melanie Boudreau, it was Melanie Pulowski, Melanie Boudreau at the time, it's now Melanie Pulowski. She lived in apartment 174, which is right next door to Lori. So at that
How about that?
point, we knocked on her apartment as well to see if Lori or JJ.
You think it should be the same font?
Did anybody answer?
No, they didn't.
Okay.
What did you do next?
I was instructed to go back to the police department, go to the prosecutor's office, to see if we can obtain a search warrant to search the residence for JJ Vallow, while the other detectives stayed on scene and started knocking on doors in that complex. At that point, our only focus was to find JJ and to figure out what was going on. So we were going to exhaust every
Ooh, I don't know
means
about that
to see what we
one.
could do. And that's why
I don't know,
went to the
man.
prosecutor's office to see if I could obtain a search warrant.
And did you obtain a warrant that day?
No.
Why not?
On the way to the prosecutor's office, Detective Hope, with the number that the defendant Daybell provided, called that number. There was no answer, but he left a message. Once we got to the prosecutor's office, Lori Vallow called back.
I don't know.
She was
With the same
instructed to
font.
open
I
the
don't know,
door.
man.
There were detectives outside of her door.
Debold his
not to
name?
speak with.
And
It's
are you
not
aware
bold.
of any detectives were able to make contact with that day?
It's not bold. It's just the font. I can't debold his name. That's just the font.
Detective Stubbs and Detective
So
Ball.
if in order to debold his name, I have to change the font.
And you had mentioned earlier that Detective Stubbs.
Okay,
had
I can't
body
debold
camera,
it.
correct?
I can't do that. I can't do that.
And do you know if their interaction with Lori Vallow was recorded?
Yes, it was.
Have you watched that video?
Yes, I have.
Well, I could do that. You like that? It's the
At
same
that
family
point in your
font, but it's a slightly
investigation,
different
what did
font.
you-
You like that one?
After
Detectives Ball and Stubbs had spoken with Lori Vallow, what did you do? What did you do next?
we were informed that JJ was with a family friend.
Judge, I'm going to object if there's any comments.
Let's sustain that.
Detective, did you speak with Detectives Ball and Stubbs about their interaction with Lori that day?
Yes,
Did you speak with them that day?
yes,
Did you watch the body cam of their interaction?
That's not
with
bad.
Lori Vallow?
yes, I did.
So you're aware of what she said.
Yeah, that's not bad.
Based on what she said to them, what did you do next in your investigation?
We attempted to locate the family friend to see if JJ was with her in Gilbert, Arizona.
And do you know who that family friend was?
Melanie Gibb,
Were you able to contact her?
I was not.
Did you have any interaction
Yeah, all right.
with
I think I
Arizona
can
law
live with that.
enforcement day about contacting Melanie Gibb?
All right, fair enough. Thank you.
It was starting to get into the later hours of that evening. So I contacted Detective Miller with Gilbert Police Department. And I had him go to Melanie Gibb's residence to see if JJ was there. Ultimately, we learned he was not there.
About what time did you learn that JJ was not with Melanie Gibb?
Roughly 9 o'clock at night.
And what did you do when you found out that he was not there?
I contacted.
Yeah. All right.
Lieutenant Ball.
I like the cleaner
and let him
look.
know.
All right, I'm changing it.
And we agreed to meet at
Thank
the
you.
prosecutor's office that next morning early to obtain search warrants for those apartments.
Okay, and just for clarity of the record, which apartments are you talking about?
Apartment 175, which belonged to Lori Vallow, 174, which belonged to Melanie Boudreaux, and apartment 107, because that's the last time JJ was seen based on the defendant Daybell's statements.
Detective, were you able to obtain those warrants?
Yes, we were.
What did you do? Well, what day did you obtain those warrants?
I think the background is pretty good on the thumbnail.
2019, in the early morning hours.
I might change that
And
later, but I think that
On
works for
that
the
day,
moment.
did you execute those warrants?
We did.
Let's talk about that. Where did you search first?
We searched apartment 175 first.
Was there a reason you searched there first?
That was his address that we were given from Gilbert Police Department. That's where his mother.
What did you find in apartment 175?
So initially, when we wrote down the door, everything looked ordinary. There were couches, there were papers on the table, there was food in the refrigerator, food in the pantry. We went upstairs, there were beds, pictures. Everything seemed that people lived there. The thing that caught our attention was there were no clothes on the hanger in any of the closets. Zero clothes. Just a bunch of empty hangers hanging there like somebody took the clothes off and left.
Did you locate JJ in that apartment?
No,
Did you see any evidence whatsoever to suggest that he had been living there?
yes, we did. There were a couple things. We located a child's Star Wars suitcase underneath a little crawl crawl space under the stairs. It was mixed in with some, what I can best describe as 72-hour kits had like, it was mixed with flashlights, flares, water. The suitcase was mixed in with those. We also found an old prescription bottle prescribed to JJ of Resperdone. And there were miscellaneous photographs of JJ in the residence.
And did you see any other evidence of any minor children?
No. Correct. We did. When we first went inside, there were some scooters and the small child's bike right on the porch.
Okay. Did you seize anything from the home that day?
We did, I seized the Resperdone and the suitcase.
After you searched apartment 175, what did you do next?
We searched 174, which was really Negro's apartment. Everything appeared normal in there. There were no signs of JJ or anything that he was even there. But we also searched apartment 107, and that was completely vacant. There was nothing in apartment 107.
Did you seize anything from apartments 174 or 107?
We seized, in apartment 174, we seized some cash, large amounts of cash that were found in the closet. And the only reason we seized those were for safekeeping, because we had to take the door in there as well. And it wasn't able to lock, so we took that.
Did you locate any weapons in any of those apartments?
So in apartment 175, when we were searching the garage area, we located several different style weapons, handguns, rifles, various calibers, army knives, a lot of different weapons that were inside there.
And why did you seize those?
Again, for safekeeping, that apartment didn't lock. And so we took those, so it wouldn't be stolen.
Did you find any evidence that JJ Vallow had been in apartment 174?
No.
Did you find any evidence that JJ Vallow had been in apartment 107?
No.
Did you search any other building that day?
We did. In apartment 175, we located a storage unit rental agreement contract. And on that storage unit contract was the name Lori Ryan. It had listed her as the tenant, and it listed the storage unit number as T52, and it gave an address of self-storage on Airport Road in Rexford. So with that information, we were able to obtain a search warrant for that storage unit as well.
And did you participate in the search of that storage unit?
Yes, I did.
What did you find there?
There were a few bikes, children's bikes. There were boxes of new clothing, some ice skates. There wasn't a lot in the storage unit. There was a personalized a family blanket, a big blanket with family photos that was sewn onto the blanket. Those photos had JJ Vallow, Tylee Ryan, and their sibling Kobe Ryan. There were pictures of Lori Vallow. But other than that, there was nothing else really in the store.
When you performed these searches, were you looking for Tylee Ryan?
No,
So to your knowledge, she hadn't been reported missing.
that's correct.
You're on quite never reached that far.
Yes.
Mr. Wood, I understand this would be a good breaking point in this testimony for the lunch hours, is that correct?
Yes, Your Honor.
Okay, we're gonna go ahead and take our lunch recess at this time. Before we do that, again, I will just advise the jurors, please don't discuss the case amongst yourselves or with anyone else over the break. In addition, for those in the courtroom, we will be closing the courtroom, I believe, during the lunch break. So things you have in here will need to go with you. We'll reopen upon the conclusion of the lunch break, and we'll still be under the court's governing order for court conduct when we return. So I think we're going fine with that. With that in mind, we'll go and take our lunch recess now.
All rise.
Did they say when they're coming back? I heard lunch break, but I didn't hear him announce a time. Did I miss it? I'm assuming I did. Okay, well, all right. Well, that'll bring us to the end of this morning session. So far, just sort of normal kind of things you'd expect. Yeah, you didn't hear of time? Yeah. So we don't have any idea what time. All right, so some indefinite time. Okay. All right. Well, I guess we'll come back at some time. I'm not sure when. That's frustrating. Yeah, plan for an hour? Plan for an hour sounds about plausible. All right, we'll plan for an hour. Cool. All right, I'm going to go ahead and I guess take a break for lunch. And we'll be back in an hour. So far, kind of what you'd expect to hear, just sort of basic stuff, just getting started. Nothing sort of write home about so far, but we'll see how it goes. Let us go ahead and create a new stream for this afternoon. We will reuse these settings. Okay. Well, really, I want to reuse these settings. For some reason, it won't let me do that. Do we like Lawyer Reacts at the front of the section of the title? Lawyer Reacts Chad Daybell. I think it distinguishes me by putting it at the front rather than at the back. But I think it's workable. All right. Okay, cool. So we got April 10 p.m. session, and we need to change the thumbnail to the one that I just created earlier today. Cool, because I think it's a better thumbnail. And we will set this to go live at 2 p.m., I guess. My time, because it's 1 p.m. now, so that'll be 2 p.m. their time. And do that. Okay, cool. So that's created. And then I need to set up a redirect. So a quick recap of the morning. Not much happened this morning. We swore in the jury. We gave some preliminary jury instructions, and we heard opening arguments. And we have just started to hear from the first witness, a detective who was trying to find the children in response to a welfare check from the grandmother. You know, where is JJ? Right? So that is this detective, right? So that's how we're starting. We got the call from grandma, where is JJ? And we're doing a welfare check, and the parents are being, less than fully forthcoming about where is JJ. So that's where that's at. Okay. What am I trying to do right now? Oh, I was trying to set up a redirect. Did I accomplish it? Oh, no, I don't think I did. No, it's under customization. I'm losing track of what I'm trying to do. All right, cool. All right, I will see you, I guess, in an hour. Until later, my friends, I hope all is well. Cheers, my friends, for now, and goodbye.